in Zambia, in Livingstone. And I'm very pleased indeed to be facilitating a discussion for this webinar entitled Justice for Our Soldiers. And I look forward to the contributions from a really excellent panel from across our Commonwealth jurisdictions. Thank you for attending. Thank you for your interest, and I hope that you will find this of benefit to you. Some housekeeping rules, please. The panelists will remain muted but on video. Everyone else should remain muted and will be off camera. And if you have a question or a greeting, can you please use the chat facility that you will find at the bottom of your screen. The Commonwealth Lawyers Association is, as the name suggests, an association of practitioners from across the Commonwealth jurisdictions. We have at our heart a passion for upholding the rule of law, identifying where there are breaches or challenges to the rule of law, and we must remain vigilant at all times because challenges are apparent wherever we are in the Commonwealth to the rule of law, particularly so in this climate of emergency legislation and justification for the stifling, perhaps, of parliamentary debate and the swift passing of legislation justified because of our health emergency. Now, that is a general background to the CLA. We run very many webinars of this sort. Only yesterday we were participating in one offering solidarity to colleagues in Sri Lanka. We have had webinars dealing with regulation of legal profession. We have one coming up on commercial courts. And we had a very interesting series on corruption and rule of law in the South Pacific and Australasia region. And that just gives an example of what CLA webinars get up to. If you are interested as an observer in what we do, please look at our website. Please feel free to join as members. And please note that we have a conference that we hope very much will be in person in Nassau, the Bahamas, in September this year, where we are very much looking forward to our program, which is entitled Sustainable Justice. And that has a whole range of meanings in terms of climate change, the right to a safe environment, responsibility for pollution, but at its heart, it has the justice theme, which of course brings me to today's theme, where we talk about justice for our soldiers. Now, I am very much approaching this webinar as a lay person, not steeped in anything military at all, but coming from Northern Ireland, I did reflect that last week a soldier entitled Soldier F was brought before the courts in Londonderry for a preliminary inquiry into what was the events of Bloody Sunday, which occurred on the 30th of January 1972. And if ever there was a case where the military and the civilian and political world collided, it might be in the history and evolution of that case over nearly 50 years. So without dwelling on the controversies and the inquiries and the rationale for not prosecuting other veterans other than this single soldier, I simply flag that military law resonates today, not least as a result of the Australian report on its military in Afghanistan, where there was some considerable criticism of the behavior of some military personnel there. So I find this topic fascinating. what are the systems in place in our Commonwealth jurisdictions? How do they reflect the principles of rule of law? How do they deliver justice for our soldiers, for our military generally, and for our society who looks on and observes? Today, where there is technology, body cams, and instant social media, how can the military processes adapt and become more efficient, more speedy, more mobile, more technological? I hope that some of these questions might be touched on as we canter through 4 jurisdictions in the Commonwealth, the UK, where we are really delighted to have the Judge Advocate, His Honour Judge Alan Large, the position in Zambia, where we have retired Brigadier General Moses Piri to share reflections on the system there. We then move to New Delhi, where Colonel Bala Subramaniam is an experienced Supreme Court advocate and former person involved in the judge advocate arrangements in India. And then we will wind up, hopefully in time for some questions and some conversation between the panel, with Alex Ward, barrister and a naval legal officer of Australia and a former president of the Commonwealth Lawyers Association. So without any further ado, in fact, no ado at all, let me move to Your Honour Judge Alan Large, who joined the Royal Navy in 1979 as a university cadet, was called to the bar in 1988, appointed a recorder in 2005, and then became Assistant Judge Advocate General in 2010. And in January of 2020, became the Judge Advocate General for the UK. Your Honour, Alan, we would love to hear from you and to share the UK process and experience for military justice and justice for soldiers. Thank you.
Thank you very much indeed, Brian. Can I just say at the outset, it's a real honour to be here with the Commonwealth Lawyers Association today. It's my first outing with your organisation, and it's very important to me because one of the things I would like to help do as Judge Advocate General in the UK is to raise the profile of military justice across the Commonwealth, because as you've said, we can all learn from each other, we can all share each other's experiences, and I've no doubt that I'm going to gain useful information and insights from hearing my colleagues speak a little later this morning. It's a great honour to be working with such high quality colleagues on the panel, but I also note from some of the audience that are joining us that we have some very distinguished members in the audience as well. So it's great to see so much interest in this subject. I think it's right to say that over the last quarter of a century, the UK has seen quite a sea change in the way we do military justice. You'll probably hear me referring to it as service justice. It's the expression we use, but it's the same thing. That was all driven by a number of decisions in the European Court of Human Rights in the 90s, late 90s, which led to changes in our systems to make sure that we achieved the necessary independence to safeguard the fundamental human right of a fair trial. And so that was the driving force which led to a number of acts of parliament, but in particular the Armed Forces Act of 2006, which is the major reforming act of parliament, creating the single service of justice for the Army, the Air Force and the Royal Navy all together into one system, establishing the court-martial as a permanent court rather than an ad hoc court convened to do a trial. This now sits permanently as a court all the time. And so that is now the foundation, if you like, of the service justice system in the UK, the 2006 Act. And it divides the service justice system into three components: summary justice, justice by the CO, then the service courts, the court-martial, the summary appeal court and the service civilian court, but primarily the court-martial. And then the appellate system through to the court-martial appeal court. I'm just going to look at each of those briefly in turn. Summary justice. I'm sure we all have summary justice systems. Why do we need it? Well, we need summary justice to ensure that the operational effectiveness of the armed forces is maintained by the work that the courts can do, the commanding officers can do in maintaining discipline. If you don't have a disciplined force, you don't have a force which can respond to some of the challenges that all of our services have to deal with when they go into difficult situations. Summary justice needs to be a number of things. It needs to be swift. If you've got an offence between a sergeant, let's say an allegation of an offence between a sergeant and a private in the same platoon, that's got to be dealt with quickly, otherwise it festers. And that festering situation can undermine morale, undermine unit cohesiveness and the like. So it needs to be dealt with quickly, it needs to be fair, and it needs to be effective. In our system here in the UK, the COs deal with, in rough figures, 90 to 95% of all the cases that come through the system. Out of those cases, and let's take a very rough figure, about 4,000 of them in our service justice system. Again, 90% plus of those are dealt with by way of a guilty plea. So the soldier, the sailor, the airman goes in front of their CO and says, yes, sir, ma'am, I did what I'm alleged to have done. And the CO will then sentence them. And I'll come on to the CO's powers of sentence in a moment. Out of all those cases that go through the summary system, about 2% result in appeals to the summary appeal court. That seems to me to be a pretty good indicator that the system is working, because, as I'll tell you in a moment, there is an unfettered right to appeal for all service personnel in the summary system. Now, there's some problems with the summary system, as you will all have realised. The first of those is that there isn't the safeguard, the human right, if you like, to a fair trial. There isn't the safeguard of an independent judge. You're being tried by your CO. Your CO probably knows you, knows whether you're a good guy or a bad guy. So there's no independence of the tribunal. There's no right to legal representation either at the hearing. You can speak to a lawyer before the hearing, but there's no right to legal representation. So how do we manage to operate a system without those fundamental safeguards? It's not ECHR, European Convention of Human Rights, compliant. You need to have right to a fair trial before an independent court. Well, there are three safeguards that allow us to operate this system. Firstly, anyone in front of the court, anyone who's in the summary justice system can elect for trial in the court-martial. So for any offence, automatic right to go for trial in the court-martial, which is a compliant court. Secondly, there is, as I've already said, an unfettered right of appeal to the summary appeal court. Even if the soldier in front of the CO admits it, says, so I did it, I did this, I did that, automatically they can go to the summary appeal court. The case will be reheard. There'll be no possibility of getting a more severe sentence. So that's the second safeguard. And the third safeguard is the review that's conducted of all summary matters that go through the system, that's conducted very quickly to check that the correct procedures have been used, that the correct sentence has been passed, that a lawful sentence has been passed. And if, for example, and this happens from time to time, the CO has exceeded their powers of punishment, very quickly brought back into the summary appeal court and rectified it's highlighted within a couple of days. So there's that safety net under the whole summary justice system. It should operate swiftly, and I think it's right to say that in general terms it does in the UK. I haven't got the statistics to hand, but most of these cases will come through the system in a matter of weeks. Some more complex cases obviously will take longer, and sometimes cases are held up by other operational requirements and the like. But it is essential that it's administered swiftly. The CO can still get legal advice, but that's turned around very quickly by the lawyers. And if you find that cases are lasting in the summary system more than a few weeks, then it's not operating properly, in my view. So there's quite a lot of pressure on COs to keep the thing moving efficiently. Moving then to the court-martial, about 400 to 500 cases a year in the court-martial system at the moment in the UK, probably closer to 400 at the moment. And a number of topics in relation to that. What's the jurisdiction of the court-martial? It's global. We can try a case involving a serviceman who's alleged to have committed an offence anywhere in the world. And we can sit globally as well. I was just talking to my colleagues before we started the webinar. Last year, I sat on part of a death by dangerous driving trial in Belize because we couldn't link to the Belizean witness. We had to take the evidence from him live. So we did part of the trial in Belize and then part of the trial back here in the UK. And my predecessor as Judge Advocate General, he took part of some sensitive evidence in Washington, rather than bringing the witnesses from the United States across to the UK, which wasn't in the circumstances possible. So we can sit anywhere in the world and we can try offending anywhere in the world. And we can try the full range of offences as well. From murder at the top end, some of you will remember the case of Sergeant Blackman, Marine A, as he was known for a long time on operations. That was a murder trial, down to the most minor offences, absence without leave, and things like that. We can try the full range. There is a debate at the moment in this country about whether the court-martial should be trying the more serious cases, murder, manslaughter, rape, serious sex offending, and that's something we may be able to talk about a little later. But that's an interesting debate that's ongoing at the moment, and it will be interesting to hear what other countries and other jurisdictions do. In terms of sentence, we have all the sentencing options open to the civilian courts, life imprisonment downwards, as well as service detention, and service or military sentences such as restrictions of privileges and the like. So we've got the full package of sentences available. I think a sensitive issue in all jurisdictions is whether civilians should be tried in service courts. My belief, and I think a lot of people believe, that they should be tried in civilian courts. Civilians should be tried in civilian courts and not in the service jurisdiction. But we do try some in our jurisdiction because there is nowhere else to try them. So if a serviceman is deployed with their family, maybe as used to be the case, a lot of people in Germany, working and living in Germany with their families, if the spouse or one of the family members commits an offence in Germany, they can be tried in the court-martial, subject to civilian law. They can be tried back in the UK or out in Germany where there's a court. And so we can catch those cases in that way. We can also catch cases where people offended in the past, as maybe if you take a historic sex case, maybe a babysitter who's alleged to have offended when they were 17 or 18 as one of the families stationed overseas, and down the line an allegation is made 10, 20 years later. This court, the court-martial, is the only court that would have jurisdiction because the babysitter, when the alleged offence was committed, was overseas in Germany or Cyprus or wherever. So we have a very few cases involving civilians. Ordinarily, it's service personnel. And as to the structures in the court-martial, again, I suspect there'll be some differences here between the various systems. The judges are all independent civilian judges appointed by the Judicial Appointments Commission and working for the Ministry of Justice rather than the Ministry of Defence. So there is a clear line between the judiciary and the MOD, and there's absolutely no possibility of any pressure being brought to bear by the MOD, by senior members of the services on the judiciary. There's no line of authority at all. Similarly with the prosecutors are independent. The Director of Service Prosecutions is a civilian appointment, senior member of the bar, now working as the Director of Service Prosecutions. He'll hold that job for 5 years, and that ensures the independence. Again, the services cannot intervene and interfere with justice and decisions such as who is prosecuted and what for. And the defence is conducted by civilian lawyers who any civilian lawyer can appear in the court-martial, providing they have rights of audience, but generally they will be criminal lawyers who practice occasionally in the court-martial, so they take an interest in military justice matters. All defendants in the court-martial are entitled to apply for legal aid in exactly the same way as civilians can apply for legal aid. They may have to make a contribution to the costs, but they are entitled to legal aid, and they're entitled to legal representation. And the system works in pretty well exactly the same way. The court works in pretty well exactly the same way as the Crown Court does. We try to reflect practices as much as possible. We try to bring in technology. Brian, you mentioned about that. During the pandemic, we've been, as many courts have been doing, operating with a lot of witnesses coming by Zoom or by Teams like we are today. And that seems to have worked rather well. So that's the way the court operates. We can come back to the hot topics of the day, such as the jurisdiction of the court and whether we should be trying cases of murder, manslaughter and rape in due course. But that's a quick run through our system in the UK.
Fantastic. Thank you so much, Alan. That was really, attention grabbing in a good way, because you said at the start that you wanted to, if you like, share the workings of perhaps a not sufficiently understood part of the justice system. And as a lay person, not being aware of the intricacies of the military service system of justice, I find that really helpful, and it has laid the ground perfectly to compare and contrast and to learn from other jurisdictions. And I will move swiftly on. And next up, we will have retired Brigadier General Moses Piri from Zambia. And Moses retired from the Zambia Regular Air Force in 2019, having completed 40 years service. 20 years, you were telling me, Moses, in operations, and then 20 years within the legal services administrative side. You are a senior advocate in Zambia and retain a practice in law, but we would like to hear from you of your experience and of what is the system of services justice in Zambia. And if you could unmute yourself and share your thoughts, we would be delighted to welcome you to this Commonwealth Lawyers conversation on our topic today. Moses, over to you.
It's truly a privilege to be on this platform today and share some brief thoughts on the Zambian military justice system. Many thanks, Chair, for your introduction. I'm mostly humbled. To address the topic before us, I would like to structure my presentation under 4 headings, namely, tenets and rationale of military justice. Second, history of the military justice system in Zambia. Third, outline of the legal framework in my country. Then lastly, I'll talk about briefly benefits and shortcomings. Now, firstly, let me proceed to talk about the tenets and rationale. I think it is very important to underscore this point as we start talking about the impact of rule and law on the military justice system, and also the aspect of impact on human rights on the military justice system. One should appreciate that from time immemorial, world over, the military has had a distinct legal system which has applied to the members for the purpose of preserving discipline and good order in its establishment, and also in ensuring its operational effectiveness. To this day, the military remains a specialized society, separate from civilian society, with laws and tradition of its own. Because of the aforementioned, and given the brutality and intensity and sheer terror of warfare, the commander traditionally has always retained a unique position as a focal point of military discipline and order in a unit. And so when we are talking about this, when a man and a woman joins the military, he or she, and this is a traditional aspect, loses many freedoms which you consider as rights in the civilian life. Such an example I'd give is a freedom to live where he or she would want to choose. Or basically, he loses the freedom to choose not to risk his life for the country. And that's basically the tradition of a military life. It's intrinsic to the military life, what we're discussing here. The operational realities of military life mean the service members are often held in high standard of conduct than would be expected in the civilian world. The reasons are clear, as I've alluded to, because military personnel are often required to risk injury or death in the performance of their duties. These realities of military life have been acknowledged in many cases. I just want to cite one, a decision which was made in Canada, basically Her Majesty the Queen against General. It's a well-celebrated case in the military. The Supreme Court in Canada ruled the following: the purpose of a separate system of military tribunals is to allow the armed forces to deal with matters that pertain directly to discipline efficiently and maintain the morale. And it goes on. And in ending, the Supreme Court in that case did say the punishments are mostly more severe than would be the case in the civilian engaged in such a conduct. This is a premise of what we're discussing about, and this being the tradition, because the commander has been the soul of discipline. However, we must still recognize that even though members of the military are held to the highest standard of conduct, they do not give up their fundamental rights to fair treatment once they've committed a crime. In the Zambian case, which was heard in the Supreme Court of Zambia, in the case of Major Isaac Masonga against the people, the Supreme Court of Zambia was very unequivocal when it stated the following: an accused person in a military trial has the same protection under the Zambian constitution to a fair trial. So you have to understand this. You're coming from a tradition where discipline revolves around the commander. He has to enforce discipline. Yet the Supreme Court says, even in that situation, the accused person does not lose a fundamental right to fair trial. This is very clear, and I think Judge will be maybe able to explain more on this, because that has had a lot of impact on the imperial statutes. When you look at Article 6 of the European Convention on Human Rights, and the changes it has had on the imperial statutes. Against this backdrop, let me just then talk about the history so that you appreciate where we're coming from. The history of the Zambian military justice system can be traced from the imperial statutes governing discipline in the United Kingdom. It is good that Judge has already talked about the changes which have happened after 2006, but majority of the Commonwealth countries still they use the imperial statutes as they were obtaining in 1955. That is the Army Act and the Air Force Act 1955 as amended time to time. So at independence, Zambia inherited the imperial statutes of the United Kingdom. Let me just say what the preliminary says. Preliminary section in part 1 of that Defense Act, it says the following: unless the context otherwise requires, the act, meaning the Defense Act, means the Army Act 1955 and the Air Force Act 1955 of the United Kingdom, as amended from time to time. So you appreciate that most of us in the Commonwealth and I've had a look at a lot of Commonwealth countries, that's the same act which is being applied. Of course, Judge will be talking about other things, what has motivated them to change. But basically, this is what is obtaining in most jurisdictions. The Army Act 1955 and the Air Force Act 1955. That is the act which we use in Zambia. That act has remained like that, and the only amendment which we basically, major amendment which we had was basically in 1985, when Act number 21 introduced a section 127. Now, it is important because I know I'll talk about this in benefits. Section 125 of the Defense Act, which was introduced in 1985, provides the following. The appointment of a judge advocate to act on a court martial may be made by the Chief Justice upon application by the commander. So that was a major thrust or amendment done, and only done in 1985. Substantially, I would say the act remains the way it has been from 1955 up to date. Let me then talk about the framework of that act, because that becomes the subject of discussion later on. The framework of the act which we have in Zambia under the Defense Act. For those of you who have had the privilege to look at the Army Act 1955 of the UK, our act, the Defense Act, is basically mirrored on that. It draws now its strength from the Constitution. That is a legal framework because the Constitution has embraced it by making further promulgation that it should be enacted. So basically the framework is from the Constitution, then the act it's itself. Now the act, in short, basically does provide few things, and again, I'll not go much into details. It provides for military offenses, the trial and punishment, then the relationship between the military courts and the civilian courts, and also the persons who are subject to military law. And I'm glad the judge already alluded to it. This is basically a continuation of the 1955 Act, which they also have in the UK, that military personnel are subject to the military justice system, but an extension is also given to civilians who have gone on active duty with the military. Now, I'll be very quick in this because Judge has already talked about it. There's very little changes which have been done to the Act. What you have in the UK at the moment is now a few changes, but what it does provide, then our Act, it basically is the two things which Judge has talked about. The summary trials, those are the main elements. First, the summary trials. These are designed to deal with relatively minor offenses by the military commander. In this case, the commanding officer. The commanding officer quickly adjudicates on these courts and imposes swift punishment relative to the minor offenses. Summary trials, like I've said before, are presided over by the commanding officer within the accused person's chain of command. And again, it would be good to understand from Judge why they have not changed that aspect, because it's still subsisting in most of the jurisdiction. The commanding officer still tries these cases. He might delegate the trying of these offenses to the subordinate commander. Basically, the accused has no right of representation in a summary trial. But we have to acknowledge that 3/4 of the cases are dealt with at summary trial. I'll be talking about maybe the weaknesses of that later when I talk about, let me hurry on because of the time given to me. Let me try to wind up. Yes.
Sorry to interrupt, Moses, but yes, if you could just briefly wind up so that the other panelists can get their opportunity.
The next one basically is the court martial. The only difference from what Judge has talked about here is basically the court martial. Its convening is done by the convening authority. Unlike the UK system, ours, we've maintained the traditional system where the commander takes full charge in convening the court martial, in appointing the members of the court martial, in appointing the people who are going to sit on the court martial. The only introduction which I talked about was basically introduction of the judge advocate. Let me briefly, in conclusion, basically talk about the benefits and shortcomings. The benefits, basically, if you notice, is now the appointment of a legally qualified judge who sits on the court martial. The judge, the appointed judge advocate, is basically answerable to the Chief Justice on the administration of justice on that court martial. The other benefit I could talk about is the rules which apply to the court martial, to admissibility of evidence, are the same rules applying in the High Court. The shortcomings are many, basically founded on the fact that the convening authority plays a multi-role in convening, drawing up the court martial, appointing members, and confirming basically what is on the court martial. One of the things I would talk about again is basically the weaknesses of this system. There is lack of tenure of people who sit on the court martial. Tenure is important when you come and talk about independence. But also, I would want to talk about the Defense Force procedure rules, which we use under the Act, are the same Act which were adopted in 1964. In conclusion, let me hasten to say that following several judicial opinions made, including the Supreme Court of Zambia, on the aspect of the 1955 Act, I wish to submit that there is an urgent need in Zambia to carefully undertake reforms which will address the issues of independence and impartiality, and also put in other safeguards, because this is important and it will be in consonance with the current trends in a modern democratic society. To ensure that the country abides by this, I would want to say at the end that these reforms should be undertaken carefully, because of a system which we have inherited, a system where the soul of discipline is a commander. So the reforms should be careful. The motivation of this should be explained to everyone, so that they appreciate what reforms you are undertaking, so that they do not resist or reject the reforms which need to be taken, especially if you have to compare the value placed on the commander, which now has been removed like in the UK system, and also the advent of human rights in this world. I submit. Thank you so much, Chair.
Excellent, Moses. Thank you so much. Sorry, I don't think I've had the opportunity to try and interrupt a Brigadier General before, and I hope that you didn't mind, just in interest of time management. Thank you once again. My knowledge has increased, and I'm noticing on the questions and on some of the chat that this is energizing our community of people who are listening in, and that there are some really interesting questions, particularly the relationship between military courts and civilian trials. And already we've had that set out for us by Judge Large and by Brigadier General Piri. But we now move to New Delhi, where we have Colonel Bala Subramaniam, a advocate of the Supreme Court of India. I was saying before we started that there are so many of the Supreme Court advocates contributing in all different ways to the work of the CLA, and it's delighted, Colonel Bala, to welcome you today. Could you share your perspective from your experience of sitting as a judge advocate in the Indian services justice system? Over to you.
Thank you, Mr. Spears. Very warm and a big namaste to all the listeners and viewers. Firstly, it gives me a great pleasure to be associated with Common Law Association in participating in this particular webinar. The topic could not have been more apt. Justice for soldiers. Coming from a military background, certainly it warmed my heart when I read the topic. And more so, since I am a practicing lawyer on the military side, it gave me an insight to study the Indian system in great perspective, and at the same time, try and learn from the contemporary systems which the learned speakers have highlighted already. Setting the discussion in context, I must point out that Indian Army is the 4th largest army in the world, and it has got a strength of 1.3 million active soldiers on duty, with a reserve of another about 9 lakhs reservists. They may be called upon to duty in times of need. We have comparatively a smaller navy with a strength of about 70,000 odd officers and soldiers, sailors, with a reserve of another 55,000. And similarly, a slightly bigger Indian Air Force with a strength of about 1.4 lakhs and a reserve of about another about 1.4 lakhs. So therefore, in the context of the Indian subcontinent, when we have adversaries breathing down our neck from all the sides, certainly the standing army has to be a huge army. And I must say that the Indian Army and for that matter, the armed forces, the Navy and the Air Force, have largely inherited the erstwhile British system of administering justice. So therefore, after the country became independent in 1947, the Army Act got enacted in 1950, supplemented by the Army Rules of 1954. Then the Air Force Act was simultaneously enacted in 1950, and the rules coming in little later, the Air Force rules. And the Navy, of course, got its own act, the Navy Act of 1957. These are all the plenary legislations which govern essentially the code and conduct of the armed forces, and at the same time ensuring that justice is dispensed to the soldier at every possible opportunity. Briefly, I will highlight this system of dispensation of military justice to soldiers in 4 parts. Part 1, I will cover the context in which the Indian Army, the Indian Navy, and the Indian Air Force dispense justice to the soldiers. In part 2, I will cover what is the existing setup or the mechanism that the forces, and for that matter, the persons who are convicted of crimes, who are convicted of military offenses, that there is independent review outside the system. And in third part, I will briefly touch upon what are the areas where we can actually reform the existing system. And of course, towards the end, I will give a brief highlight of certain important, in fact, landmark judgments so far as the administration of military justice in India is concerned. So taking first the system within the armed forces of dispensing justice. As his judge, Honorable Mr. Allen pointed out, we have largely borrowed from the British system. So therefore, the summary jurisdiction, the power of the commanding officer and superior military commanders to summarily punish the offenders remains primarily and predominantly the biggest support system as far as disciplining the soldiers are concerned, the erring soldiers are concerned. This is supplemented, of course, in graver offenses by conducting court-martials. In the case of Army, of course, we have different types of court-martials. And in the Air Force, we have similar types of court-martials, barring certain differences. And in the Navy, of course, the Indian Navy follows one system of disciplinary courts in certain contingencies and another trial by court-martial in case of serious offenses, besides summary punishments. So if I touch upon the summary jurisdiction, essentially it revolves around the commanding officer, because the thrust and the philosophy bestowing upon the commanding officer the powers to summarily punish not the officers, but of course the soldiers, essentially, revolves around the fact that he is the person who has to lead the men in battle. So therefore, he knows the best as to how the unit is to be run, how the unit is to be administered, and how the unit is to be made battle ready for combative effectiveness. And at the same time, indiscretions on the part of soldiers and minor offenses when they are committed, the commanding officer deals with them sternly and swiftly. In the context of the Indian Army, the summary punishments range from giving an imprisonment up to 28 days and minor other punishments like awarding them extra guards and duties. But the important feature of this summary trial by the commanding officer is that it firstly ensures that while the offenses are not overlooked, especially the military offenses, like say, for example, overstaying the leave granted or otherwise minor disobedience of orders and cases of intoxication and simple assaults, etc. They have been, in fact, given the power, the commanding officers, to impose the punishments so that they are dealt very swiftly, and at the same time, the Act provides that there is a review carried out by the superior military authorities, and in case if any of the procedures or any of the punishments are found to be illegal or unjust, the superior military authority is vested with the power to cancel it or remit it or to pass such other orders as the superior military authority may deem fit and proper. So there is an inbuilt mechanism in the Act itself that these are regularly reviewed and at the same time ensure that justice is done to the soldier. And while, as the old age adage goes, every innocent should not be punished, but at the same time, the guilty should not be spared. This is the cornerstone or the principle underlying the summary punishments. Who knows better than this other than the commanding officer? Therefore, essentially, the majority of cases, whether it is of the Army or the Air Force or the Navy, are dealt summarily by the commanding officer. Of course, the Act has given powers to punish in the case of junior ranking officers to certain superior military authorities. A brigade commander or a divisional commander has got summary punishments to either reprimand the officer or, in case if the offense warrants, a slightly more harsher punishment of forfeiting the seniority or forfeiting the service up to a prescribed period. This is, of course, only up to a particular level ranking officers. Beyond that, if an offender, depending upon the rank and also depending upon the seriousness of the crime, If offenses are very grave or serious enough, then of course, the option of trying the individual by a court-martial always is there. So in this context, I would like to actually submit that there are 4 different types of court-martials, apart from the general and district and summary general court-martials. The important aspect of a summary court-martial, a power which is much debated, so far as the Indian Army is concerned, it has been a subject matter of discussion, wide-ranging discussions, subject matter of a recent litigation before the highest court of this country, where the court found, in view of certain shortcomings in the system of holding summary court-martials, because it is widely perceived this is a system by which the commanding officer, who alone constitutes the court, he can hire and fire somebody, even right up to extending imprisonment up to 1 year of service, 1 year, or dismissing the person from service. So therefore, this had become a subject of heated discussion, and ultimately the Supreme Court of India has drawn the contours, or so to say, laid down certain parameters in which the power of summary court-martial to be exercised. Of course, if the needs of discipline or the expediency of justice or the situation demands a swift and immediate action by the commanding officer, certainly it is not that he is actually without any power. To that extent, the contours have been redefined. Nevertheless, this trial by summary court-martial and the summary punishment by the commanding officer is the major instrument by which the military justice in Indian Armed Forces is sought to be, in fact, preserved. Adverting to the Indian Air Force and the Navy, they don't have the system of summary court-martial. The Air Force has got a system of general district and summary general court-martials. And the Navy, of course, being a smaller force, has got only one system of court-martial. Apart from, of course, in times of war, etc., they have the disciplinary courts. Now, this is in broad how the system of administering justice in the armed forces is sought to be, in fact, achieved. Coming down to the investigation part, which preludes the conduct of a court-martial, the commanding officer has got enormous powers to investigate the offense, either by ordering an inquiry, which is essentially a fact-finding inquiry, before deciding to further course of action. And if need be, he can always refer the matter to the superior authorities if the incidents are very serious and it warrants investigation at a higher level.
Colonel
This
Bala,
is how...
Might I just give you one minute to maybe wind up? I mean, fascinating, and we clearly should have allowed twice the time, but to facilitate some discussion at the end, and Alex coming in, could I give you 1 minute to wind up, please?
Thank you, Mr. Spears. I will do that. So this is how actually the system of justice is sought to be preserved in the armed forces. Within the system, as I said earlier, like in the context of summary punishments, in case of court-martials, certainly the Act provides for the post-decision petitions, which are independently examined and a decision is arrived at. The second tier of review of the system of dispensing military justice way back in 1982 is outside the system. Way back in 1982, the Supreme Court of India observed that when the civilian counterparts have got right to appeal after appeal, file appeals against the convictions, why not our service people are robbed of such an opportunity? With that aim, the system of establishing a tribunal, armed forces tribunal, was suggested by the Honorable Supreme Court, and it took about more than 25 years to bring in a legislation in the form of the Armed Forces Tribunals Act in 2007. Now, this Armed Forces Tribunal is entirely an independent setup, which has got nothing to do with the armed forces. So therefore, it is a statutory tribunal functioning outside the realm of the hierarchy of the Indian dispensing military justice system. Now, they have got twin powers, that is the power to decide the service matters when a person has got problems with regard to promotions, the confidential reports, the summary punishments, etc. The service matters are dealt with. And at the same time, an effective remedy of appealing against the court-martial's verdict, which is as good as a fresh trial being conducted by the Armed Forces Tribunal. This is by far one of the most, in fact, landmark, in fact, legislation which has brought in, where the outside the system, an independent machinery is provided for to review the system of court-martials and to review the verdict of the court-martials. Then in the third hierarchy, we have the Supreme Court of India, where every soldier has been given a right to statutorily appeal to the Supreme Court of India. Of course, this is with a rider that leave has to be granted by the Armed Forces Tribunal in case if it involves a question of public importance, or in case if the leave is refused by the Armed Forces Tribunal, then of course, leave can be granted by the Supreme Court of India and hear the matter. So therefore, essentially, it's a three-tier system as it is existing today. Administration of justice by the system of Army, Navy, and the Air Force, and independent review by the Armed Forces Tribunal, followed by, if need be, the Supreme Court looking into the matters of military. Apart from this, the constitutional courts in various states, which are the high courts in the country, they also have got superintendents, of course, with regard to the other tribunals, but there is a raging debate, and the matter is sub judice before the highest court, whether the high courts would exercise jurisdiction and superintendence over military tribunals. Because constitutionally, there is a forbidden clause that superintendence does not extend to tribunals constituted for the armed forces. But as a constitutional court, which is one of the basic structures of the Indian constitution, certainly the constitutional courts, including the high court, wield enormous power and they can review anything. This is, of course, subject to the final decision which will be taken. This is so far as the system is concerned. Quickly, in fact, recapitulating.
I am going to have to, because we're at the 11 already, and you've had, I think we've got a really good grasp of common issues in terms of the system, the summary justice dispensation, the clash potentially of those service arrangements with the human rights arrangements. And it may be you will get another opportunity a little bit later, but would you mind if I paused you there? Can I thank you for that contribution? We will bring you in later, but I want to bring in our last speaker now. Can all the speakers look at the questions that have been posed? And there is a theme in some of them emerging between the entitlement for some serious offences to be tried in military courts rather than in civilian courts. And I think that might be something after Alex that we would ask Judge Large to maybe reflect upon. Alex, for the meantime, let me move to you. Colonel Bala, you could maybe put yourself on mute in case there's an interference. Thank you so much.
Thank you. Thank you.
Colleagues listening and present, our final panelist is from South Australia, the magnificent city of Adelaide. He was president of the Law Council of Australia in 2011 and president of the Commonwealth Lawyers Association, this very association of which I am now president in 2015 to 2017, succeeded by Santan, our magnificent former vice president, who has been again responsible for promoting and encouraging this, and I suspect is listening now. And we thank again Santan for all his great work in pulling these together. But Alex is, I a commander in the Royal Australian Navy and chair of the Military Legal Service Ethics Advisory Committee. Alex, you have heard from 3 jurisdictions: history, evolution, former statutes that are being updated in the UK but still operated elsewhere. Could you give us your perspective from Australia, please?
Thank you, Brian, and thank you very much, ladies and gentlemen, for your interest, and for Judge Large, who was the driver in doing this. It's going really well. The Australian situation is similar to all that have been described, but we do have our differences. So I'll focus on that reasonably quickly, in that we have the summary justice, which everyone's described as working and being the big driver of most of the dealings, where you have the commanding officer or a senior officer in a regiment or on a ship or at the airfield is actually doing the decisions. We had some difficulties back in around the early 2000s, where there was a parliamentary inquiry into the effectiveness of the summary justice or the justice system, where it was considered that perhaps it wasn't working properly, in that results might have been preordained and that sort of thing, which is a problem you have when there's not oversight. And so steps were taken in Australia to change that. Before that, we also had the 3 separate legislations and the 3 separate defence forces. It was all united back in about 1985 under the Defence Force Discipline Act, which brought everything together. So the 3 forces all work under the same rules, which is very sensible. And then what's happened in that, and this now contrasts to the English system, is that you have the summary justice, which is dealt with at the unit or ship level. Then you have the higher level, more serious offences, or as Judge Large said, where the person in the summary offence can say, I want to go to the more serious level. Good thing to you is that you might have more independent dealing with the case. Bad thing for you is that you put yourself up for higher levels of sentence. So there's a bit of a gun to your head there. And that's not for everything. You couldn't put up there for absent without leave, or I was 5 minutes late, or something like that. There's a certain criteria. Now, what happens at that level, as to contrast to the English system, is that everything's done in uniform. So your judicial officers are, they're uniform, they're full-time judicial officers, and there are part-time ones as well that come in to deal with the trials. We have a registrar of military justice who is again in uniform, and they see to the organising of cases. So you're taking command very much out of the picture once you get into this more serious level. We have the Office of the Director of Military Prosecutions, certainly in the UK, the DPP equivalent. You have an independent, full-time prosecuting service, all in uniform. And then you have the Directorate of Defence Counsel Services, and that's a directorate that then, when old Jack Tar or the soldiers got in trouble and is being prosecuted, the Director of Defence Counsel Services assigns legal officers to them. So unlike the English system, your access to a qualified lawyer is supplied. As your food supplied, your uniforms, your dental, your medical, you also get lawyers. And I think that's, on the discussion we've had, it may be quite unique. It certainly sets us quite at odds from the UK system, in that it's fully funded by the government. That's part of your rights as a soldier, sailor or airman. You actually get access to legal. That's if you're being prosecuted under the Defence Force Disciplinary Act for a defence offence, or you might be subject to administrative inquiry, and you might get a notice to show cause of your being kicked out of the army. You get access to a lawyer, which is funded by, not by you, but by the government or part of your service, to assist you in doing these administrative actions. So it's very good. I mean, it's rolled gold for the people who are being prosecuted. They have access to that. The people doing it, by and large, are very experienced lawyers. The reserve lawyers will be out there practicing at the bar every day, honing their skills. Then they're trained in their services. I was trained in the Navy, the others, the Air Force and the Army. And so you go and work for people. We work across the board. Most of my work is for soldiers. And I have a recurrent business out of one of the regimental dinners every year. I know I'll be getting a call a couple of weeks later. So that's nice to see. Just in terms of numbers, now I think Australia probably, I'm not sure, General Firry of your case, but we'd certainly be the smallest in terms of population. So the Defence Legal has, that's the overarching body. We've got 127 permanent officers working there. So 127 permanent officers in uniform. They've got another 40 officers who are public servants. And they have paralegals and support staff in addition to that. And there's 384 active reservists like me who come in and work as required. So it's actually a very, very large body. In Australian terms, that would be a very large firm, which is Defence Legal, all working to provide those services. So similarities that we have that difference of provision of services to the soldiers. The similarity is that it's a discipline act. I agree with the Colonel Bala Sumarium that the discipline's really important. It's a very important aspect that you do have that at command level, that people are being dealt with. To protect that, because as Judge Large said, at that lower level, the CO is a gifted amateur who has received some training and might have a book which is about this thick to read. It's too much. But they pretty much know what's what, and they're dealing with a lowish level, and they know about what's happened. I'm absent without leave. They can understand that. They're represented by generally people at the unit. It might be a sergeant, or the lieutenant will stand up as a defending officer. So they have that help. And the matters at that level are subject to automatic review by qualified legal officers. So there's that protection. The Defence Force discipline matters are court-martials, which will have a Defence Force magistrate sitting alone, or a panel of various numbers depending on the severity of the offence. And then we have the Defence Force Discipline Appeal Tribunal, which is in our federal courts. Everything gets paid for up to that level. If the person then wants to go off to appeal to the High Court, they pay themselves. So it's a very good legal aid for the soldiers. Brian, those are the, I'll put into that because time is scarce. We want to have some questions. So our system is quite similar to what's been described, but they're the serious differences in that you've got a lot more access to qualified lawyers to get involved in the process. Now, here I'm only speaking as a civilian. I'm certainly not speaking on behalf of the ADF, but you pick things up, and sometimes the command gets a bit scratchy with the soldiers being so lawyered up and there being so much oversight of what they do. So that's a tension. I think that's a positive tension, but it's certainly there, an issue that occurs. We're reviewing matters all the time as we go. Our summary stuff was just too complicated, I think. And for the people using it, not being lawyers, it's complicated for lawyers. So we're looking to simplify that in the near future. But we're always checking, are our systems working properly? Now, an important matter that's sort of been a bit of a catalyst for this, of course, is the situation in Afghanistan over many years, which has been subject to an inquiry. We have the Inspector General of the Australian Defence Force, which is another part of our legal system, which reviews matters. And so the inquiry, what we call the Afghanistan Inquiry Report, which you would have heard about last year in this, was really grew on the basis of rumours. There being rumours going about that things had occurred. And the inquiry was to look at, well, is there anything behind these rumours? And the inquiry's gone for many years and very carefully looked at this. Now, I would think, Brian, the Commonwealth Law Association, this is a matter of the rule of law in positive application. So you have a country like Australia who is involved in Afghanistan, and things are happening there, people might think, beyond the sight of others. Well, it shows that Australia will say, wait on, we're hearing some bad things here. We have the mechanism for inquiry. We'll spend enormous resources to inquire into these rumours. And that has now evolved into this very detailed report, which is available publicly in a highly redacted fashion. Now, as it's a report, a bit like a coronial inquiry, the evidence that's obtained can't then be simply transferred to a criminal case, because there's limitations on the right of silence, there's limitations on self-incrimination. because command has to find out what's happening. We need to fix this first. But now that's given rise to probably setting up a series of investigations at a criminal level and then prosecutions at a criminal level. Now, I mention that because there's some questions have been raised about that as we've been talking. But I think if I finish there, we could, all of us could go on for some long time talking about our systems and the comparisons between them. But I'll shut that off there so we can have some questions.
Brilliant, Alex. And indeed, I don't think I've been in one of these webinars that has stimulated quite such a range of interest from the delegates. And it really does make you hope for some sort of in-person meetings, because we could have a whole day-long conference on these issues. Indeed, the latest submission was from one of your countrymen, Alex, Lieutenant General Gunn, wanting to reconvene soon.
Just think lieutenant. Let's not over promote Gunny.
Well, anyway, the suggestion that we need to reconvene to give proper respect and attention to these serious matters is a very, very good idea. And I'm mindful that people have set aside slots of time, and we may not be able to give full appropriate time to the very important questions. But I would like to return, Judge, to you, mindful of your position as a sitting judge advocate. But have you had time to look at the questions, Alan? Have you reflected on this tension between command and control and human rights, the organizational efficiency of swift decisions, which is maybe a little bit of rough justice, courts compared to military courts? Could you share any reflections with us, please?
In that regard, I think the command is central to summary justice. And I was interested to hear about the magistrate sitting in the Australian system. That's something that's been discussed over the years over here as well. But the armed forces regard the command as being the centre of the military justice system. And I think they're probably right to do so, because of as colleagues said earlier on, of what the services can be required to do. And the command and the people serving under the commanders must know that they can exercise authority and discipline in the most difficult of circumstances. But you have to back it up. Alex, sorry, were you going to say something?
Yeah, I was going to say Judge, that's why I mentioned in your situation. So you'll sit in the civilian courts. Do you sit with a military jury?
I sit in the Crown Court as a judge in the Crown Court, but in the court martial, I sit as the judge, exactly the same in the Crown Court, but I have a military jury, a military board of, at the moment, either 3 or between 5 and 7 people. So there's a military board. They decide on verdict. So they will decide guilt or innocence in the same way a jury would decide in the Crown Court. When it comes to sentence, that's the big difference, because the board members, the lay board members, also sentence with me. I will guide them on the guidelines, the parameters, but they have an equal vote and voice with me as well. So I regularly sit with service colleagues from warrant officers upwards and get the service input from them as to how serious it is, or otherwise. They can provide the service context, and I will then with them sentence. So it's a joint exercise, if you like.
From a lay person's point of view, such as mine, I mean, I'm really learning about this important context of command, of what we expect service personnel to do for the benefit of our countries and our society. Is there any anxiety about this tension between their rights and this method of dispensing justice? Are we all satisfied that the balance is struck correctly, that there is a court-martial justification for military offences? I see some of the questions and answers really quite split on this, particularly for some of the more serious offences. And Colonel Bala, you look as if you're minded to contribute on this issue, the balance between military courts and civilian courts, particularly maybe for more serious events.
Thank you, Mr. Spears. It's essentially military courts versus civil courts. What is the balancing factor? Which is the best system? Both has got ups and downs. If you look at actually the military courts, the predominant factor why a soldier should be tried by a military court is the expertise and the experience that the military man has got. Because he is born and brought up in the system, he knows the rules and regulations well, he knows the procedure, he knows the context in which a particular offense has been committed. Vis-a-vis the civilian courts, they are, to be very frank, may not be totally aware of the military way of life or the military etiquettes and the customs and traditions of the service. This is one aspect which needs a lot of introspection. The second is, of course, the efficiency. The military court can dispense justice very quickly without compromising the basic tenets of rule of law, whereas the civilian courts can drag on and drag on for years and years. And eventually, even if a conviction or an acquittal is actually announced, it may end up with delayed justice is amounting to denial of justice.
Yes, I was wondering about the, I mean, when we hear about, oh, there's a right to appeal from the commanding officer, and then there's other rights built in, and some have rights of representation and others not. I mean, it almost seems to me as if there's a danger of a sort of a delay in the system of dispensing military justice. Alex, you're on sort of both sides of this from a lay person as well as the military. Do you think there's too much of appeals and rights and that gets in the way of efficiency and operational justifications?
It's certainly the case, Brian, that the point of discipline, it's got to be close. It's got to see, I've done this and I'm being dealt with it. The message goes to all the other people in the unit, don't do this. So it's got to be done fairly quickly. If you're being punished for being absent on leave 2 years after the event or something more serious, it's rather losing the point from the discipline. Yes, it's disciplining the individual, but as for sort of maintaining discipline in the Defence Force, delay is a real problem.
What about appeals, Alex?
Well, yeah, but that's the trouble, of course, Brian, as we know in the CLA, that you've got, it's the balance. You march in the guilty bastard. That's quick, it's dealt with, can't appeal. He knows what the penalty is going to be before he even pleads because somebody's told him. That's how it was in the old days. So you need to have this checks and balances to stop railroading of people for convenience. Yeah. Convenience for them, convenience for the unit. We've ticked our boxes, we're doing the right thing. So, and then the more serious it is, the more there has to be delays, because you can have imprisonment is a punishment of choice. So you've got to imprison people, you've got to kick them out of the Defence Force, they lose their career and they're dishonourably discharged. They have to be able to have the right. In Australia, we give people rights to lawyers. Other jurisdictions might say, don't, keep the lawyers away because they just mess things up. So there is a tension there. Hopefully it's healthy, but I do agree, Brian, that delay is a real problem. They've got to go through expeditiously, so there's no injustice to the prosecution or, of course, to the accused.
Moses, do you have a view on how is Zambia doing with delay and these the need for discipline and the need to balance the rights of the individual? Just a quick comment from you, and then I'll bring Judge Large back in.
My considered view over this matter is a conundrum which exists between the tradition and the modern, and that has to be brought in context every time you discuss this matter. Judge had already talked about the central role the commander plays, and that has been the tradition in warfare because of saying we need to maintain order and discipline. We are an efficient system. That's how the military is recognized. Now, the balancing act, which basically comes up, is basically now where you are saying the various statutes now provide that your system should exercise independence and impartiality in relation to what is obtaining in the civilian court system. And I think that is a bottom line which we all of us should agree on, that unless this is understood and inculcated into our troops and also the civilians, there will be like a pool. This has to be understood because the commander on one side is saying, this is how this system works. It's meant for war. It's not meant for any other thing. And like I did allude to earlier on, you are talking about certain peculiar things which are not normal in the normal sense, in terms of sacrifice, ultimate sacrifice by an individual to die for the country and the commander's responsibility. And especially now, when you come and start looking at the Rome Statute and the responsibility, Article 28 places on the commander in the theater of war. These things are real. And we now are saying, given the judicial opinions which have been made, we need to reform this. The efficiency is always there in the military. I don't know how the Australians will be handling where matters are handed over to the civilians. I'll leave it to them. But in our context, this is an issue which is important because our practice shows that there is no lag in efficiency.
Mm-hmm.
With
well,
the military system.
I mean, I would be really intrigued. It's almost like the contract when you sign up requires you to submit to a system of dispensation of justice that needs to be well understood. I'm also interested in what seems to be a divergence in some of our jurisdictions between the involvement of exclusively military personnel in decision-making, in prosecuting and defending, and the involvement of civilians. And I think we will reconvene this panel to have session 2 to explore some of these issues. But I wonder, Alan, would you comment just on those general themes that have emerged just in the last few minutes about civilian prosecutions, efficiency, the need for command, the context? That seems to me to be a fascinating area, and you're at the forefront of it in the UK.
It is a fascinating area, and it's fascinating to hear the differing views coming out of panelists as well, which is makes this type of webinar so interesting. From my perspective, the most important thing is getting the cases tried in the most appropriate tribunal, the most appropriate court. And that court has to be fit for purpose. So if the court is the summary jurisdiction, then it's got to have all the safeguards attached to it to make sure that it is compliant with the human right to a fair trial. And I went through earlier how we try and achieve that in the UK. If it's going to be the court-martial, then the cases coming to the court-martial have got to be properly investigated, properly prosecuted, and properly tried. There have been a number of questions about this issue at the moment in the UK about where the most serious cases, murder, manslaughter, rape, and serious sexual assault, should be tried. And there is an active debate going on about that, and I'm not going to get drawn into it any more than I have been in the past, other than to say this. The cases, in my view, should be tried in the most suitable venue. So if there is a court such as the court-martial, which is fit and capable properly of trying those cases, and there is a significant service context, then they should be tried there. And if there isn't, they should be tried in the civilian jurisdiction. But I acknowledge openly that there is a completely different school of thought, which is that those matters should be tried. The default position is that those matters should be tried in the civilian courts. And that is another point of view which I respect. My view happens to be slightly different from that, but that's the position. I think there are various ways of doing it. As long as the system that is chosen to administer justice for the services is fit for purpose, then I think we're all right with that.
Well, we are now approaching 90 minutes for this particular event, which is really at the outside edge of what we can allow for this type of webinar. I note that our participant level has remained very constant throughout, which is a testament to each of our panelists' draw, but more than that, the interest and the very insightful contributions that you have each made. I, for one, would be up for a Justice for Soldiers webinar number 2 to draw together some of these learning points, because it has been genuinely fascinating. So I'm sorry to disappoint those that are still asking questions. I know that the questions really need to be brought together in a format that allows for answers. This issue of tension has just been mentioned on the Q&A between the military context, the need for command, and taking it out into a civilian rule of law, right to a fair hearing, endless representation and procedural fairness arguments. But I think I must draw this to a conclusion. Alex needs to get some beauty sleep, although very little for you, Alex, I think is required. The rest of us, for me, I need to get on with my day. I have found this a real privilege, and I'm sorry to draw it to a close. I hope that you might agree to reconvene, and we'll take the discussion forward. And Your Honour, insofar as your ambition is to create more interest in the Judge Advocate's Court in this issue of military law, I think this has been a magnificent contribution. And so I thank you for your very much your leadership role in participating and taking part so generously today. Thank you for that. To our contributors from India and from Zambia, I say thank you so much. It's been passionate, it has been insightful, and it has been wise. And Alex, it is great to hear from you with your contributions so energetically given. But could I simply say, on behalf of the Commonwealth Lawyers Association and the participants that are out there listening avidly, please send in your contributions. Participants, please join as members so that you don't miss out the announcement of our webinar number 2 on this topic. And thank you for making this such a success. But goodbye, good night, good afternoon, good morning to you all. And Claire, if you might want to jump in and bring this to a close. It has been recorded, I believe, Claire, if you are there. And I think anybody that wants to relive this fascinating experience, the opportunity is there. So I'm going to bow out. Thank you, Colonel Bala. Thank you, Brigadier General Moses. Thank you, Alex. And very much thank you to the Judge Advocate of the UK, Judge Large. Let's bring this to a close. Claire.